Good day, everyone. We are the Group 2, and I will be your first presenter for this topic. And the topic that I will be discussing to you is the title 4 Powers of Corporations. The rest of the topic will be discussed to you by my group mates. This power of corporations is exercised by its board of directors and duly authorized officers and agents, except in instances where the corporation code requires stockholders' approval for a certain specific task. We have to note that a corporation has no power except those expressly conferred on it by the corporation code and those that are implied or incidental to its existence. Works of a board of directors, like signing of documents, can be performed only by a natural person duly authorized for the purpose by the corporate bylaws or by a specific act of the board of directors. Section 35, Corporate Powers and Capacity. Every corporation incorporated under this code has the power and capacity of the following. Number 1, to sue and be sued in its corporate name. This simply means a corporation can initiate legal action and be sued in its corporate name. B. To have perpetual existence unless the certificate of incorporation provides otherwise. This simply means that a corporation has the right to continue its existence even if its members or stockholders change. C. To adopt and use a corporate seal. To amend its articles of incorporation in accordance with the provision of this code. This simply means somehow changing the rules and provision of the articles of incorporation. They are allowed to amend that. And letter E, to adopt bylaws not contrary to law, morals, or public policy, and to amend or repeal the same name in accordance with this code. Letter F, if a corporation is a stock corporation, they are allowed to issue or sell their stocks and treasury stocks to subscribers in accordance with the provision of this code, and to admit also new members of the corporation even if it be a non-stock corporation. Furthermore, letter G, to purchase, receive, take or grant, hold, convey, sell, lease, pledge, mortgage, and otherwise deal with such real and personal property, including securities and bonds of other corporation, as transaction of the lawful business of the corporation may reasonably and necessarily require, subject to the limitation prescribed by the law and the Constitution. And letter H, to enter into a partnership, a joint partnership, joint venture, merger, consolidation, and any other commercial agreement with natural and juridical persons. Letter I, corporation is also allowed to make reasonable donations provided that it is for public welfare, for hospital, charitable, cultural, scientific, civic, and other similar purposes, provided that no foreign corporation shall give donations in aid or for the purpose of partisan political activity. Letter J, to establish pension, retirement, and other plans for the benefit of its directors, trustees, officers, and employees. And letter K, to exercise such other powers as may be essential or necessary to carry out its purpose or purposes as stated in the articles of corporations. The 11 powers of corporations that I have discussed to you a while ago are those general powers of corporation which are exercised by board of directors and or its duly authorized officers and agents. Power to extend or shorten corporate term. A corporation may extend or shorten its term as stated in the Articles of Corporations, provided that there is an approval by a majority vote of the Board of Directors or Trustees and ratification by the stockholders representing at least two-thirds of the outstanding capital stock or by at least two-thirds of the members in case of a non-stock corporations. The corporate term may be extended for periods not exceeding 50 years in any single instances as provided by the Section 11 of the Corporate Code. No extension can be made earlier than 5 years prior to the original or subsequent expiry dates unless there is a justification or justifiable reasons for an earlier extension as determined by the SEC. We have to note that a corporation cannot extend its life by the amendments of its articles of incorporation effective during the 3-year statutory period for liquidation when its original term of existence had already expired. Here are the requirements of extending or shortening the corporate term as discussed earlier. Now let's proceed with the appraisal right. Right simply means that a stockholder can demand or can withdraw from corporation by demanding payment of the fair market value of his shares provided that he dissented or voted against to the proposed corporate actions. Power to increase or decrease capital stock, incur, create, or increase banded indebtedness. For corporation to increase or decrease their authorized capital stock, the following requirements must be met. Number 1, written notice of the proposed increase or denomination of the capital stock and of the time and of the place of the stockholders meeting at which the purpose or proposed increase or denomination of the capital stock is to be considered must be addressed to each stockholder at his place of residence as shown on the books of the corporation and deposited to the addressee by mail or served personally or through electronic means recognized in the corporation's bylaws and or the commission's rules as valid mode of service of notices. Number 2, no decrease of the capital stock shall be approved if its effect shall prejudice the rights of corporate creditors. Under the provision of this code, no corporation shall increase or decrease its capital stock or incur, create, or increase any banded indebtedness unless approved by a majority vote of the Board of Directors. There is a ratification by the stockholders holding at least two-thirds of the outstanding capital stock, and a certificate must be signed by the majority of the directors of the corporation and countersigned by the chairman and secretary of the stockholders meeting, and there is approval thereof by the Securities and Exchange Commission, and lastly, treasurer's affidavit showing that at least 25 of such increased capital of the stock has been subscribed and at least 25 of that amount subscribed has been paid. There are three instances of distribution of corporate capital. The trust fund doctrine provides that the subscription to the capital stock of a corporation constitute a fund to which the creditors have the right to look for the satisfaction of their claims. This doctrine is the underlying principle in the procedure for the distribution of capital assets embodied in the Corporation Code. This allows the distribution of corporate capital only in three instances. Number 1, amendment of the Articles of Incorporation to reduce the authorized capital stock. Number 2, to purchase of redeemable shares by the corporation regardless of the existent unrestricted retained earnings, and the dissolution and eventual liquidation of the corporation. Another power of corporation is to deny preemptive right. So what is preemptive right? A preemptive right, it is the preferential right of all stockholders of a stock corporation to subscribe to all issues or disposition of shares of any class in proportion to their respective shareholdings. Furthermore, preemptive right simply means to establish a prior right. A stockholder's preemptive right is his right to subscribe to a new shares of stock in proportion to his existing stock holdings before the new shares are issued to others. All of this right is enjoyed by all of the stockholders, unless such right is denied by the Articles of Incorporation or an amendment thereto, provided that such preemptive right shall not extend to shares issued in compliance with laws requiring stock offerings of minimum stock ownership by the public, or to share issued in good faith with approval of the stockholders representing two-thirds of the outstanding capital stock in exchange for property needed for corporate purposes or any payment of a previously contracted debt. Another power of corporation is the power to sell or other disposition of assets, subject to the provision of Republic Act number 10667, otherwise known as the Philippine Competition Act, and other related laws. A corporation may, by a majority vote of its board of directors or trustees, may sell, lease, exchange, mortgage, pledge, or otherwise dispose of its property and assets upon such term and condition and for such consideration, which may be money, stocks, bonds, or other instruments for the payment of money or other property of or consideration, as its board of directors or trustees may deem expedient. Another requirement is there should be written notice of the proposed action and of the time and of the meetings shall be addressed to each stockholder or member at his place of residence as shown on the books of the corporation and deposited to the addressee in the post office with postage prepaid, or served personally or when allowed by the bylaws, or done with the consent of the stockholders, sent electronically. Number two, there should be an approval of the majority vote of each board of directors or trustees, and there is a ratification by the vote of stockholders representing at least two-thirds of the outstanding capital stock, or in case of non-stock corporation by vote of at least two-thirds of the members, and any dissenting stockholder may exercise his appraisal right. Power of corporation to acquire own shares. Under the provision of this code, it enumerates 7 instances a corporation may acquire its own shares. Number 1, to eliminate fractional shares arising out of stock dividends. Number 2, to collect or compromise an indebtedness to the corporation arising out of unpaid subscription in a delinquency sale, or to purchase delinquent shares sold during the said sale, to pay dissenting or withdrawing stockholders entitled to payment for their shares under the provision of this code. 4, to acquire treasury shares, redeemable shares regardless of existence of retained earnings. 6, to effect a decrease of capital stock. 7, and to close corporations when there is a deadlock in the management of the business. The Securities and Exchange Commission may order the purchase at their fair value of the shares of any stockholder by a corporation regardless of the availability of unrestricted earnings in its books or by the other stockholders. Power to invest corporate funds in another corporation or business or any other purpose. Here are the requisites. To accomplish its primary purpose, there should be an approval of the majority of the board of directors or trustees, and the approval of the stockholders or members shall not be necessary. The following are requisite to accomplish a purpose other than the primary purpose. Number 1, approval of the majority Number 1, approval of the majority of the board of directors or trustees. Number 2, there should be a ratification by the stockholders representing at least two-thirds of the outstanding capital stock, or by at least two-thirds of the members in case of non-stock corporation, at a stockholders or members meeting duly called for the purpose. And number 3, the same with other provision of the code. there should be a written notice of the proposed investment. Number 4, any dissenting stockholder shall have appraisal right, and the ratification must be made at a stockholders or members meeting duly called for the purpose. Power of the corporation to declare dividends. Under the provision of this code, the board of directors of a stock corporation may declare dividends out of the unrestricted retained earnings, which shall be payable in cash, property, or in stock to all stockholders on the basis of outstanding stock held by them, provided that any cash dividends due on delinquent stock shall first be applied to the unpaid balance on the subscription plus costs and expenses, while stock dividends shall be withheld from the delinquent stockholders until their unpaid subscription is fully paid, provided further that no stock dividend shall be issued without the approval of stockholders representing at least two-thirds of the outstanding capital stock at a regular or special meeting duly called for the purpose. So here are the difference between cash dividends and stock dividends. Another power of corporation is the power to enter into management contract. Under the provision of this code, it states that no corporation shall conclude a management contract with another corporation unless such contract is approved by the board of directors and by the stockholders owning at least the majority of the outstanding capital stocks, or by at least a majority of the members in the case of non-stock corporation of both the managing and the managed corporation at the meeting duly called for the purpose. Management contract is an agreement whereby a corporation delegates the management of its affairs to another corporation for a certain period of time. It has to be noted that under this provision of this code, it only refers to a management of contract with another corporation. Therefore, it does not apply to the management contracts entered into by a corporation with a natural person. So this simply means such contract that is made is between two or more corporations. Another power of a corporation is ultra vires act of corporations, which means beyond the powers. It is an act taken by a corporation that exceeds its legal authority as defined by the Code of Corporations, Bylaws, or Constitutions. One of its example is a corporation exceeding financial limits. A company taking a loan that is beyond the authorized financial limit specified in its article of corporation. That concludes for my part, and the rest of the topics will be discussed to you by my group mates.
So let's go to Title 5, Name Bylaws. Bylaw has nature and purposes. So sa nature signifies the rules and regulations or private laws enacted by the corporation to regulate, govern, control, in its own actions, affairs, and concerning its stockholders or members, and directors and officers with the relations thereto and among themselves with the relation thereto. So basically, it's all about the rules and regulation para sure or para matiyak na maayos yung operation at pamahala within the company itself or within the corporation itself. While in the purpose to regulate the conduct and define the duties and members toward the corporation and among themselves. So basically, while in purpose is about how maiwasan yung mga hindi pagkakaunawaan and matiyak yung lahat ng may part na gumaganap ng kanilang responsibility ng maayos for the sake ng corporation. So bali in the slide, so the section 45. So, about siya sa pagkuha ng bylaws. So, ibig sabihin ng ito is that na need na ma-approve yung mga bylaws ng corporation. So, kailangan yung na need magpasang-ayon yung mga majority ng stockholders na may hawak na hindi bababa sa kalahati ng kabuuang kapital ng stocks. So, bali, yung ng kabuuan ng stock na corporation. So, para naman sa mga non-stock na corporations, kailangan na yung pagsang-ayon ng majority sa kanilang mga miyembro. So, bali yung pagbibigay or pagsumiti ng mga bylaws ay need ng way better or kailangan na gawin na matapos na paglikha ng corporation upang ito ay magsimula yung operation niya mismo. So, bale, itong slide na to is may tanong dito. So, are the third person bound by law? So, the answer is, it is a generally accepted rule that the third person are not bound by laws. So, except when there are knowledge of the provision, either actually or constructive. So, ito yung mga third person, these are those that are not part of corporation. So, bali, yung nakalagay dito is, so, except na lang if they are knowledgeable. Like, alam nila na yung their knowledge sa provision, they're actually or constructively. Bylaws are subordinate to the articles of incorporation. So, bali, nakalagay dito is that bylaws may be necessary for the government of the corporation, but these are subordinate to the articles of incorporations as well as the corporation code or latest statutes. So, bali, kung may conflict sa pamagitan ng bylaws at an article of incorporations or batas, so mananaig yung sa huli. Next slide. Section 6. In order to effectively exercise such jurisdiction, the Commission shall possess the following powers. So, to suspend or to revoke after proper notice and hearing the franchise of or certificate of registration of corporations, partnership, or association upon any of the grounds provided by law. Bali, nakalagay dito na kaya nila kunin or suspendin or bawin yung prangkisa or certificate ng pag-register ng isang corporation, partnership, o association, including itong failure bylaws within the required period. So, bylaws are indispensable to corporations as the rules and regulations are private laws enacted by the corporations to regulate, govern, and control its own action. So, basically, it is ensuring order and consistency in the decision making. So, they establish the framework or managing the corporate affairs. So, defining the rules and responsibilities of the stockholders, directors, and officers, making them indispensable for effective corporate governance. So, sa effect of substantial compliance with laws naman is a corporation must comply ng mga certain conditions such as yung adopting and filing it by laws to fully establish its legal existence. However, kapag yung corporation is substantially complies, meaning it met the essential requirements even if there is a minor deficiencies. So, it is still considered na perfect in corporate personality and can continue operating as a legal entity. Adoption of bylaws. Sa adoption bylaws, there are two. Before incorporations or pre-incorporations and after incorporations or post-incorporation. And before incorporation, all incorporation must sign and approve the bylaws, which are then filed by the SEC along with the articles of incorporation. Meanwhile, yung post-incorporation naman, if bylaws were not adopted earlier, they can be approved later by the majority vote of stockholders or member who must also sign them. So, articles of incorporation versus bylaws. So, sa articles of incorporation, it is condition precedent in the acquisition of corporate existence. So, bali, need ng pauna na condition bago magkaroon ng legal na pag-iral ng isang corporation. So, para mas maintindihan, so, hindi maaaring makabuo ng corporation, maaaring makabuo ng corporation kung wala ito. Meanwhile, sa bylaws naman, it is a condition subsequent. So, it is absence merely furnish a ground for the revocation of franchise or certificate of registration. So, bali, need ng isang kasunod na kondisyon. So, pwede pa rin mabuo yung corporation, pero hindi maaaring maging dahilan ito para bawiin yung prangkisa or registration kung hindi ito magtatakpada. To further understand, so yung Article of Incorporation versus Bylaw. So, Article of Incorporation established siya as a corporation existent and serve as a fundamental law. They must be executed before incorporation and can only be amended by a majority of board and approval ng 2/3 of the stockholders or members. So, the power to amend cannot be delegated to the board. Meanwhile, yung bylaws naman is outline the corporation's internal rules and regulation. So, sila yung nag-create before, after incorporations and may be amended by the majority of board and stockholders or members. So, yung power nila to amend can be delegated to the board with 2/3 ng approval of stockholders or members. Contents of bylaws. So, a private corporation may provide the following and bylaws, which is already presented in the slide. So, all of the contents of bylaws are needed to establish a structural framework for the corporation's operations and governance. So, they provide kasi ng clear guidance or essential matters such as the meeting, votings, procedures, qualifications, and duties of directors and officers. Also, the penalties for violation, ensuring the smooth decision-making and compliance with legal requirements. So, moreover, well-defined bylaws contribute to efficient corporate management, good governance, and the protection ng shareholders' interests. Arbitration agreement may be provided by the bylaws pursuant to Section 181 of the Code. So note, a private corporation may provide its bylaws, the modes by which the stockholders, the members, the directors, and or yung trustees may attend meetings and cast their votes. Also, yung private corporation may provide in its bylaws the maximum number of other board representatives that an independent director or trustees may have, which shall in no case be more than the number prescribed by the SEC. Also, yung arbitration agreement may be provided by the bylaws. Section 47 or amendments of bylaw. So, ito lang naman yung mga bylaws na pwedeng ma-amend, repealed, or replaced to the approval of both. So, first is yung a majority of board of directors or yung trustees. Tapos, yung a majorities of stockholders for stock corporation. Members naman for non-stock corporations. Tapos, changes may be made during the regular special meeting that is properly called for its purpose. O, diba, nasabi ko na nga yung about sa amendments of bylaws. So, itong general rule niya, parang parehas lang siya sa gi-explain ko kanina. So, let's go for the exemption niya. So, yung exemption niya is that the stockholders or members owning at least 2/3 of the outstanding capital stock or membership may delegate its power to the board of directors or trustees. So, may note din na nakalagay na nagsasabi na any power delegated to the board of directors or trustees to amend or repeal by the laws or repealed any bylaws or adopt new bylaws shall be considered or representing the majority of the outstanding capital stock or a majority of the members in non-stock corporations shall be voted at a regular or special meeting. May note din na nakalagay na the amendment of the new bylaws shall only be effectively upon the issuance of the SEC of a certification that the same is in accordance with the revised corporation code and other relevant laws. So, binding effect of bylaws, there is two. First is on directors, officers, stockholders, or members. So, they are bound by the bylaws and must comply. So, as they are presumed to know the provision. So, yung pangalawa naman is on the third person. They are not bound unless they have the actual or the constructive knowledge of the bylaws. Next is Title 6, Meetings. Stockholders or members, meetings are held to elect directors or trustees and to approve important corporate actions such as amendments to the articles of incorporations and bylaws, asset sales, mergers, and other significant business matters. Remote communication. So basically, this is the data transfer between devices in different locations. So next is teleconferencing. So basically, it is a conference held via telecommunication devices like phones and computers. Video conferencing. So it is a conference using transmitted audio and video signals. Next is the computer conferencing. So, that is the teleconferencing supported by the computers. Next is the audio conferencing. So, it is the conference where participants communicate via telephones or the internet. Teleconferencing is an interactive group communication. So, it's two or more people in two or more locations. So, through an electronic medium. Next is group communication has three basic. Next is group communication has three basic type. So it has video conferencing, computer conferencing, and audio conferencing. Group communication has three basic types: video conferencing, computer conferencing, and audio conferencing. First is the video conferencing. So what is the video conferencing? So it is the television-like communication with sound. Next is computer conferencing. It is those printed communications via keyboard terminals. So next is audio conferencing. So it is a verbal communication through telephone, sometimes with telewriting or telecopying features. In time, people found it advantageous to hold teleconferencing in the course of business. So, and corporate governance because the money is saved. So, among other advantages, 9 that's already presented in the slide. Next is the advantages. So, these advantages exist because teleconferencing eliminates geographical barriers. It also reduces cost and enhances efficiency in communication and decision making. Additionally, it ensures continuous communication between headquarters and remote teams. So making the business operations smoother and more effective. Also, there is still disadvantages. So why are these disadvantages? On the other hand, other private corporations opt not to hold teleconferencing because of the following disadvantage. So the 8 that was presented on the slide are those. So these are the disadvantages because they hinder the effective communication, collaboration, and engagement during the meetings. According to Section 48, there are kinds of meetings. Those meetings are directors, trustees, stockholders, or members, regular or special. So basically, there are two meetings, the regular and the special. So yung nakaiba lang ng dalawa is that the regular meetings are held annually on a date set by the bylaws, and if not specified, anything after April 25 as decided by the board. At each regular meeting of stockholders or the members, the board of directors or trustees shall endeavor to present to stockholders or members the following was shown in the slides. So this report ensures that the transparency and accountability and a good corporate governance. So the slide is all about the requirements of stockholders or members meetings to be valid. So as you can see, it's already presented in the slides. So these requirements ensures that the meeting legitimacy. Section 50, place and time of meetings of stockholders or members. So stockholders or members meetings, whenever regular or special, must be held at the corporation's principal office, as stated in the Articles of Corporations. If not feasible, the meetings may be conducted at the same city or municipality where the principal office is located, including designated metropolitan areas like Metro Manila, Metro Cebu, and Metro Davao. Notice of meeting must include first the agenda for the meetings. Tapos, next is the proxy form of the submitted of the corporate secretary in advance. The guidelines for remote participation and voting if applicable. Procedures for nominating and elections of directors or trustees if the meeting involves elections. So these requirements ensures the transparency and participation of corporate decision making. Two kinds of meetings, the regular meetings and special meetings. So when bagay held yung regular meetings? So it is held annually on the date set by the bylaws or after April 15 as determined by the board. While yung special meetings naman is held anytime as necessary as stated by the bylaws. So where naman yung regular meetings? So it is held in principal office of the same corporation, or if not practicable, at the same city or municipality, or in Metro Manila, Metro Cebu, or Metro Davao, and other metropolitan areas, for the purpose of the stockholders or members meeting the considered city or municipalities. So, bale, ang where ng regular meetings, pati special meetings, are same lang sila. Sa notice naman, sa regular meetings, it is written notice must be given at least 21 days before the meeting unless otherwise stated by the bylaws or regulations. While the special meetings naman it is written notice must be given at least 1 week before the meeting, so unless otherwise specified. Section 51, Quorum in Meetings. So, a quorum is met when a stockholders holding majority of the standing capital stock or majority of the members for non-stock corporations are present. So, unless otherwise stated in the corporation's Code of Bylaws. And Section 173 naman, so as outstanding capital stock is defined, the term outstanding capital stock is used in the code. Means the total shares of stock issued under the binding subscription contract to the subscribers or the stakeholders, whether fully or practically paid except the treasury shares. Section 52 of Corporation Code, now Section 51, is about how a quorum is determined by the majority of members based on the actual voting rights, not simply by the original number stated in the Articles of Corporation. Now let's go to the Articles of Incorporation versus the Stock Transfer Book. So, ano ba pinagkaibahan ng Articles of Incorporation sa Stock and Transfer Book? So, Article of Incorporation serve as the Charter of Corporations. So, it defines that the contractual relationship between the state and the corporation and its stockholders. Yung Stock and Transfer Book naman is a record book, keeping book listing stockholders' names, address, and stock subscriptions, payments, and stock transferred as required.
Participation in stockholders or members' meetings through remote communication. If a stockholder or member intends to participate in the meeting through remote communications, he or she shall notify in advance the corporate secretary or the presiding officer of his or her intention. And then the corporate secretary shall note such fact in the minutes of the meeting. Next is the quorum in meetings. So a quorum shall consist of the stockholders representing a majority of the outstanding capital stock or a majority of the members in the case of non-stock corporation. A stockholder or member who participates through remote communication or in absentia shall be deemed present for the purposes of quorum. Next is voting and election of directors, trustees, and officers through remote communication. So the right to vote of stockholders or members may be exercised also through remote communication or in absentia, when authorized by a resolution of the majority of the board of directors, provided that the resolution shall only be applicable for a particular meeting. Next is the internal procedures. So for the convenience of their stockholders and members, corporations shall issue their own internal procedures embodying the mechanisms for participation in meetings and voting through remote communication or in absentia. The internal procedures may be provided for the following: A. Mechanism to verify and identify of the stockholders or members and who among them have the right to vote during the meeting. Letter B. Measures to ensure that all stockholders or members have the opportunity to participate in the meeting, including an opportunity to read or to hear the discussion substantially. Letter C. Mechanism to enable stockholders or members to vote during the meeting, including ensuring that the integrity and secrecy of the votes are protected. Letter D. Procedures for documenting the meeting and any process or motion which may be done afterwards. Letter E. Mechanism in making the record of the meeting, either video or audio recording, available to the stockholders or members. And lastly, other matters to address administrative, technical, and logistical issues. Next is notice of the meeting. So written notice of regular meetings may be sent to all stockholders or members through electronic mail or other similar manner as may be stated in the bylaws. Notice of regular meetings, which should state the date, time, and place of the meeting, must be sent to every stockholders or members at least 21 days prior to the scheduled meeting unless longer time is provided in the bylaws. Um, Next is notice of special meetings, which should state the date, time, and place of the meeting must be sent to every stockholders or members at least 1 week prior to the scheduled meeting unless a longer time is provided in the bylaws. And in case of postponement of stockholders or members' regular meetings, written notice shall be sent to all stockholders or members of record at least 2 weeks prior to the date of the meeting. Notice shall further be accompanied by other relevant matters such as the following: A. The agenda of the meeting. B. When attendance, participation, and voting by remote communication or in absentia are authorized, the requirements and procedures to be followed when a stockholder or member elects either option. Letter C. Manner of casting of votes, and the period during which vote by remote communication or in absentia will be accepted. Letter D. Contact information of the secretary or office staff whom the stockholder or member may notify about his or her option. Letter E. When the meeting is for the election of directors or trustees, the requirements and procedures for nomination and elections. And letter F. The fact that there will be visual and audio recording of the meetings for future reference. Place of meetings of stockholders or members. So the presiding officer shall call and preside the stockholders or members' meetings, whether regular or special, at the principal office of the corporation as provided in the Articles of Incorporation, or, if not applicable, in the city or municipality where the principal office of the corporation is located. Section 52. Um, Regular and special meetings of directors or trustees in quorum. Unless the Articles of Incorporation or the bylaws provides for a greater majority, a majority of the directors or trustees, as stated in the Articles of Incorporation, shall constitute a quorum to transact corporate business, and every decision reached by at least a majority of the directors or trustees constituting a quorum. So, sinasabi dito na sa meeting ng directors or trustees, whether it is a regular or special meeting, is dapat in quorum siya. So, kung halimbawa merong 10 directors or trustees ang isang corporation, kailangan 6 sa kanila ang present sa meeting para masabing in quorum yung meeting. But, if provided sa bylaws ang kung ilan ang quorum, yun dapat ang sundin nila. For example, if stated sa bylaws na 8 ang quorum ng meeting, 8 ang quorum ng meeting, dapat sa 10 directors or trustees is 8 ang mag-attend para in quorum yung meeting. Kasi yun nga yung stated sa bylaws. Except for the election of officers, which shall require the vote of a majority of all members of the board, shall be valid as a corporate act. So, sa voting or elections naman, sabi dyan, ang required ang voting ng majority of all members. So, kung may 10 na directors and then 6 lang ang present, dapat yung 6 na yun is mag-vote kasi nga majority of all members para maging valid yung votings. Next is regular meetings of the board of directors or trustees of every corporation shall be held monthly unless the bylaws provide otherwise. So, kaya siya monthly kasi ang Board of Directors ang governing body ng corporation. So, kailangan hands-on sila sa duties and responsibilities nila sa corporation. Next is special meetings of the board of directors or trustees may may um, may be held at any time upon the call of the president as provided in the bylaws. So, dito is pagdating sa special meetings, anytime pwede magkaroon ng meeting basta magpatawag ang president or ang president ng meeting. Ang president ng meeting. Meetings of directors or trustees of corporations may be held anywhere inside or outside of the Philippines, unless the bylaws provide otherwise. Notice of regular or special meetings stating the date, time, and place of the meeting must be sent to every director or trustee at least 2 days prior to the scheduled meeting, unless a longer time is provided in the bylaws. A director or trustee may waive this requirement either expressly or impliedly. So, anywhere inside or outside the Philippines, pwedeng i-held ang isang meeting. Pero kapag provided sa bylaws na inside the Philippines lang, pwedeng i-held yung meeting, then yun dapat yung sundin ng mga corporation. For example, if stated sa bylaws na within Cotabato lang, pwedeng i-held yung meeting, then yun dapat yung sundin nila. Hindi sila pwedeng mag-go outside or lumabas ng Cotabato City para i-held yung meeting. Next, notice of regular or special meeting, the date, time, and place of the meeting must be sent to every director at least or trustee at least 2 days before the scheduled meeting. So, this is because dapat efficient ang mga directors or trustees pagdating sa ganyan. Directors or trustee who cannot physically attend or vote at board meetings can participate and vote through remote communications such as video conferencing, teleconferencing, and other alternative modes of communication that allow them reasonable opportunities to participate. So, kahit na not physically present ang isang director or trustee is pwede pa rin sila mag-cast ng vote nila. Directors or trustees cannot attend or vote by proxy at board meetings. So, kung ang stockholder or shareholders is pwede ang proxy sa kanila. Pagdating naman sa trustees and directors, it is not allowed. Dapat personal talaga or personally nilang igagawin yung vote. Director or trustee who has a potential interest in any related party transaction must recuse from voting on the approval of the related party transaction without prejudice or compliance with the requirements of Section 31 of this code. So basically, dito, yung interlocking directors is hindi dapat sila mag-participate kasi possible na may conflict of interest pagdating sa kanila. Next is, what is the quorum of the meeting? So, dito, katulad ng sinabi ko kanina, kung merong 10 directors, 50% doon plus 1 ang quorum. So, kung merong 10 directors, 6 sa kanila yung quorum. Yung 6 sa kanila kailangan present para masabing in quorum yung meeting. Section 53. Who shall preside at meetings? The chairman, or in his absence, the president shall preside at all meetings of the directors or trustees, as well as of the stockholders or members, unless the bylaws provide otherwise. So usually, ang chairman ang nag-preside sa meeting. Pero if wala ang chairman, then pwedeng mag-preside ang president. Next is board meetings of directors or trustees. So, pagdating sa participation in board meetings through remote communication, internal procedures. If a director or trustee intends to participate in a meeting through remote communication, he or she shall notify in advance the presiding officer and the corporate secretary of his or her intention. The corporate secretary shall note such fact in the minutes of the meeting. Corporations may issue their own internal procedures for the conduct of board meetings through remote communication or other alternative modes of communication to address administrative, technical, and logistical issues. Pagdating naman sa quorum, wala siyang pinagkaiba sa mga stockholders. So, unless the revised corporation code or the articles of incorporation or bylaws of a corporation provide for a greater majority of the directors or trustees as stated in the articles of incorporation shall constitute a quorum. A director or trustee who participates through remote communication shall be deemed present for the purpose of attaining quorum. Next is the notice of the meeting. So the corporate secretary shall send the notice of the meeting to all directors or trustees in accordance with the manner of giving notice as provided in the bylaws. So notice of meetings may be sent to all directors or trustees through electronic mail, messaging service, or such other manner as may be provided by the bylaws or by board resolution. Next is notice of regular or special meetings stating the date, time, and place of the meeting must be sent to every director or trustee at least 2 days prior to the scheduled meeting unless a longer time is provided in the bylaws. So, ang notice of the meeting ng board meetings ng directors or trustees shall include the following information: A. The date, time, and place of the meeting. B. The agenda of the meeting. C. All pertinent materials for discussion which shall be numbered and marked in such manner that the director or trustee can easily follow and participate in the meeting. D. That a director or trustee may participate via remote communication. E. Contact information of the corporate secretary or office staff whom the director or trustee may communicate. Letter F. When the meeting is for the election of directors or trustees or officers, the requirements and procedure for nomination and election. And letter G. The fact that there will be a visual and or audio recording of the meeting. And letter H. Other instructions to facilitate participation in the meeting through remote communications. Roll call. So this usually done at the start of the meeting. So the presiding officer shall instruct the corporate secretary to make a roll call. So every attendee shall state for the record the following: Number 1, full name and position. Number 2, location. Number 3, confirmation that he or she can clearly hear and see the other attendees. Number 4, confirmation that he or she received the notice of the meeting, including the agenda and materials. And number 5, specify the device being used. For example, smartphone, tablet, laptop, desktop, television, whatever device na gamit niya. Thereafter, the corporate secretary shall confirm and note the participants and certify the existence of quorum. Pagdating naman sa voting. So, in case of a need to vote in any item or matter in the agenda, the presiding officer shall direct the corporate secretary to note the vote of each director or trustee. So, the director or trustee participating in the meeting via remote communication may cast his vote through electronic mail, messaging service, or such other manner as may be provided in the internal procedures. The vote shall be sent to the presiding officer and the corporate secretary for notation. Next is the other duties of the corporate secretary. So the corporate secretary shall also assume the following responsibilities. So may 6 other responsibilities dito ang isang corporate secretary. First is to ensure that suitable equipment and facilities are available for the conduct of meeting by remote communication. Number 2, ensure that the attendees are able to hear and see the other participants clearly during the course of the meeting and that attendees should be able to communicate and understood by other party. Number 3, ensure that the visual and audio recordings of the meeting are secured. Number 4, ensure that the visual and audio recordings of the election or meeting are current and ongoing and that there is no stoppage or interruption. Should an interruption or stoppage occur, the recording shall restart from the point where it was stopped or interrupted with proper statement of points in time. Number 5, ensure to safe keep and perpetuate and updated date storage equipment or facility the visual and audio recordings. Number 6, require those who attended the meeting through remote communication to sign the minutes of the meeting whenever the act of signing is practicable on a reasonable time after the meeting. So, Section 54. Right to vote, secured creditors and administrators. In case a stockholder grants security interest in his or her shares in stock corporations, the stockholder grantor shall have the right to attend and vote at meetings of stockholders the unless the secured creditor is expressly given by the stockholder grantor such right in writing which is recorded in the appropriate corporate books. So example, may utang ako, and then sa that contract is stipulated doon na binibigyan ko ng right si creditor ko on my na magkaroon siya ng right to vote as a shareholder of this particular corporation. So ang stockholder grantor is yan siya si debtor. Although ginawa niyang collateral ang stock niya is may karapatan pa rin siya doon. May karapatan pa rin siya doon kasi siya pa rin naman yung owner. Unless kapag binigyan ng karapatan expressly ni grantor yung secured creditor niya na siya na ang mag-participate, then okay lang as long as it is recorded in the books of corporation. Executors, administrators, receivers, and other legal representatives duly appointed by the court may attend and vote in behalf of the stockholders or members without any need of any written proxy. So dito is hindi na kailangan ng written proxy kapag yung nag-attend is duly appointed by the court. Kasi nga court na mismo yung nag-appoint dun sa tao na yun. So, legal na siya. Next is Section 55. Voting in case of joint ownership of stock, the consent of all the co-owners shall be necessary in voting shares of stock owned jointly by 2 or more persons unless there is a written proxy signed by all the co-owners authorizing one or some of them or any other person to vote such share or shares, provided that when the shares are owned in an and or capacity by the holders thereof, any one of the joint owners can vote said shares or appoint a proxy thereof. So kung maraming may-ari ang shares, kailangan magkasundo silang lahat bago bumoto. Ibig sabihin, kung two or more ang nagmamay-ari ng shares jointly, hindi maaaring isa lang ang magdesisyon kung paano iboboto ang shares. Kasi nga jointly siya. So parang one for all for one sila, ganon. Kailangan lahat sila ay mag-agree. Kung may nakasulat na proxy, pwedeng isa lang ang bumoto. Ang owners ay maaaring magbigay ng isang authorization ganon sa proxy na pipirmahan nilang lahat na magbibigay ng right sa isa sa kanila o kahit sinong ibang tao na bumoto sa kanilang shares. So kapag ang shares ay pagmamay-ari sa and or na paraan, sino man sa kanila ay maaaring bumoto. Kung ang pagmamay-ari ng shares ay nakasaad bilang Or hindi na kailangan magkasundo ang lahat ng owners ng share. Kahit isa lang sa kanila is pwede nang bumoto or mag-appoint ng proxy para sa pagboto. Next, Section 56. Voting right for treasury shares. Treasury shares shall have no voting right as long as such shares remain in the treasury. So, si treasury shares is wala siyang voting right kasi it is owned by the company itself, not the investors. Kaya wala siyang voting right. Section 57. Manner of voting, proxies. Stockholders and members may vote in person or by proxy in all meetings of stockholders or members. So, dito naman is pagdating sa voting, pwedeng directly mag-vote in person or by proxy or substitute. When so authorized in the bylaws or by a majority of the board of directors, the stockholders or members of corporations may also vote through remote communication or in absentia, provided that the votes are received before the corporation finished the tally of votes. So kahit di physically present ang isang stockholder, pwede pa rin siya mag-vote through remote communication or in absentia. Like sa Zoom meeting or sa Skype. Provided na ang votes ay na-receive before the tally finishes. A stockholder or member who participates through remote communication or in absentia shall be deemed present for purpose of quorum. So yun nga, kahit na through remote communication present yung isang stockholder is considered pa rin siya as present for the purpose of quorum. The corporation shall establish the appropriate requirements and procedures for voting through remote communication and in absentia, taking into account the company's scale, number of shareholders or members, structure, and other factors consistent with the basic right of corporate suffrage. So this means that corporation must set clear rules and procedures for shareholders to vote even if they are not physically present. They can vote through remote communication like online voting or in absentia, which is submitting votes in advance. So the rules should be based on factors like the company's size, number of shareholders, and structure, while ensuring that every shareholder's voting rights are protected. Proxies shall be in writing, signed and filed by the stockholder or member in any form of authorized in the bylaws and received by the corporate secretary within a reasonable time before the scheduled meeting. Unless otherwise provided in the proxy form, it shall be valid only for the meeting for which it is intended. No proxy shall be valid and effective for a period longer than 5 years at any one time. So proxies must be in writing. So a shareholder or member must create a written proxy, sign it, and submit it. Next is must follow company bylaws. The form of a proxy should comply with what is allowed in the corporation's bylaw. Must be submitted on time. So the corporate secretary should receive the proxy within a reasonable period before the meeting. Valid for a specific meeting. So unless stated otherwise in the proxy form, it is only valid for the meeting it was intended for. Hindi siya pwedeng gamitin ulit sa another meeting. Next is maximum validity of 5 years. So a proxy cannot be effective for more than 5 years at a time. So 5 years lang yung limit ng isang proxy. Next is the difference between the voting trust agreement and the proxy. So, a voting trust agreement, it is governed by the law on trust, while ang proxy is governed by the law on agency. So, next sa voting trust agreement is the trustee acquires legal title to the shares of the transferring stockholder. Only beneficial title remains with the stockholder. While sa proxy naman has no legal title to the shares of the principal. Sa voting trust agreement, the trustee votes as owner, while sa proxy is the proxy votes as a agent. Sa voting trust agreement, the agreement must be notarized, while sa proxy need not be notarized. Sa voting trust agreement, the trustee may vote in person or by proxy, while sa proxy is the proxy must vote in person lang. Sa voting trust agreement is the trustee is not limited to act at any particular meeting, while sa proxy naman can only act at a specified stockholders meeting. Sa voting trust agreement, a trustee can vote even when the stockholder is present, while sa proxy can only vote in the absence of the owners of the stock. Sa voting trust agreement, an agreement must not exceed 5 years at any one time except when the same is made a condition of a loan, while sa proxy is usually of shorter duration, although the corporation law provides that it cannot exceed 5 years at any one time. Sa voting trust agreement, as a rule, a voting trust agreement is intended to be irrevocable for a definite and limited period of time, while sa proxy, as a rule, is revocable. Voting trust agreement, a trustee has the right to inspect corporate books, while proxy does not have the right of inspection of corporate books. Voting trust agreement, the stock certificate shall be cancelled and a new one in the name of the trustees shall be issued, stating that they are issued pursuant to a voting trust agreement, while sa proxy there is no cancellation of a stock certificate. There are 5 requirements for validity of a proxy. First, it shall be in writing in any form authorized in the bylaws. Second, it shall be signed by the stockholder or member. Number 3, it shall be filed before the scheduled meeting with the corporate secretary. Number 4, unless otherwise provided in the proxy, it shall be valid only for the meeting which it is intended. And number 5, no proxy shall be valid and effective for a period longer than 5 years and at any one time. The purposes of proxies are the following. First is for convenience. Second, it assures the presence of a quorum. Third, it enables those who do not wish to attend the meeting to protect their interest. And lastly, it secures voting control. The right to vote by proxy may be exercised in any of the following instances. First, election of the Board of Directors or Board of Trustees. Number 2, voting in case of joint ownership of stock. Number 3, voting by trustee under voting trust agreement. Number 4, voting by members in non-stock corporation. Number 5, in cases of pledge or mortgage of shares. Number 6, in all meetings of stockholders or members. And number 7, in all other matters as may be provided in the bylaws. So, the revocation of proxies. So, meron lang tatlo dito, which is formal notice, verbal communication, or true conduct. Section 58. Voting trusts. So, one or more stockholders of a stock corporation may create a voting trust for the purpose of conferring upon a trustee or trustees the right to vote and other rights pertaining to the shares of a period not exceeding 5 years at any time, provided that in the case of a voting trust specially required as a condition in a loan agreement, said voting trust may be for a period exceeding 5 years, but shall automatically expire upon full payment of the loan. A voting trust agreement must be in writing and notarized, and shall specify the terms and conditions thereof. A certified copy of such agreement shall be filed with the corporation and with the commission. Otherwise, the agreement is ineffective and unenforceable. The certificate or certificates of stock covered by the voting trust agreement shall be cancelled and new ones shall be issued pursuant to said agreement. The books of the corporation shall state that the transfer in the name of the trustee or trustees is made pursuant to the voting trust agreement. This paragraph, a voting trust allows one or more stockholders to transfer their voting rights to a trustee for a certain period, giving the trustee the authority to vote and exercise other rights over the shares. So this arrangement can last for a maximum of 5 years, except when it is required as a condition for a loan agreement. In such cases, the voting trust may extend beyond 5 years but will automatically expire um, once the loan is fully paid. So, to be valid, the voting trust agreement must be in writing, notarized, and filed with both the corporation and the Securities and Exchange Commission. So, if it is not properly filed, the agreement will be considered ineffective and unenforceable. So, once the agreement is in place, the original stock certificates involved will be cancelled and new ones will be issued in the name of the trustee. Additionally, the corporation's records must indicate that the shares have been transferred under a voting trust agreement. So this ensures transparency and proper documentation, preventing any misissue of voting rights or misuse of voting rights. The trustee or trustees shall execute and deliver to the transferors voting trust certificates which shall be transferable in the sum and the same manner with the same effect as a certificate of stock. So this means that once a voting trust is created, the trustee or trustees must issue voting trust certificates sa mga stockholders who transferred their shares. So these certificates serve as a proof that the original stockholder is my beneficial interest pa rin in their shares, even though the voting rights have been transferred to the trustee. Additionally, these voting trust certificates can be transferred just like a regular stock certificate, meaning they can be bought, sold, or assigned to others with the same legal effect as transferring actual shares. So this ensures that stockholders retain some level of control over their investment while allowing a trustee to manage voting rights. Voting trust agreement filed with the corporation shall be subject to examination by any stockholder of the corporation in the same manner as any other corporate book or record, provided that both the trustor and the trustee or trustees may exercise the right of inspection of all corporate books and records in accordance with the provisions of this code. So this means that the voting trust agreement must be accessible for examination by any stockholder, um, just like other corporate records. Stockholders have the right to review the agreement to ensure transparency and proper corporate governance. Additionally, both the trustor and the trustee are entitled to inspect all corporate books and records as permitted by law. So this ensures that both parties remain informed about the corporation's affairs and the voting trust is managed properly. Is any other stockholder may transfer the shares to the same trustee or trustees upon the terms and conditions stated in the voting trust agreements and thereupon shall be bound by all the provisions of the said agreement. So this means that kahit sino pa sa stockholders sa corporation has the option na i-transfer ang shares nila to the same trustee or trustees under the same terms and conditions set in the existing voting trust agreement. Next is no voting trust agreement shall be entered into for purposes of circumventing the laws against anti-competitive agreements, abuse of dominant position, and anti-competitive mergers and acquisitions, violation of nationality and capital requirements, or for the perpetuation of fraud. So this means that a voting trust agreement cannot be used as a tool to bypass or violate laws related to fair competitions, corporate ownership, or fraud prevention. Next is, unless expressly renewed, all rights granted in a voting trust agreement shall automatically expire at the end of the agreed period. The voting trust certificates, as well as the certificates of stock in the name of the trustee or trustees, shall thereby be deemed cancelled, and new certificates of stock shall be issued in the name of the trustor. So, katulad lang din to siya kanina na this means that a voting trust agreement is only valid for a period of stated in a period of time stated in the agreement unless it is expressly renewed. Once the agreement time expires, the trustee automatically loses all voting rights granted under the agreement. At that point, the voting trust certificates were issued to be and the stock certificates in the trustee's name are considered cancelled. New stock certificates will then be reissued in the name of the original stockholders, which is sila yung mga trustors, effectively restoring their direct ownership and voting rights. Voting trustee or trustees may vote by proxy or any manner authorized under the bylaws unless the agreement provides otherwise. So, pwedeng mag-vote ang proxy basta authorized siya ng bylaws unless kung may ibang nakasabi sa agreement, then that's another case. Three tests of voting trust agreement. First, that the voting rights of the of, of the stock are separated from the other attributes of ownership. Number two, that the voting rights granted are intended to be irrevocable for a definite period of time. Number three, that the principal purpose of the grant of voting rights is to acquire voting control of the corporation. So there are also requirements and limitations imposed on voting trust agreement. Number one is the agreement must be in writing and notarized and specify in terms of conditions thereof. Number two, a certified copy of such agreement shall be filed with the corporation and with the Securities and Exchange Commission. Otherwise, the said agreement is ineffective and unenforceable. The certificate or certificates of stock covered by the voting trust agreement shall be cancelled, and new ones shall be issued in the name of the trustee or trustees, stating that they are issued pursuant to said agreement. Number four, the books of the corporation shall state that the transfer in the name of the trustee or trustees is made pursuant to said voting trust agreement. Number five, the trustee or trustees shall execute and deliver to the transferors voting trust certificates, which shall be transferable in the same manner and with the same effect as certificates of stock. Number six is the voting trust agreement shall be entered into for a period not exceeding 5 years at any time. However, in the case of voting trust specifically required as a condition of a loan agreement, said voting trust may be for a period exceeding 5 years but shall automatically expire once a full payment of the loan is made. So basically, ito siya is nakalagay na rin sa nakalagay na dun sa first paragraph um, ng section 58. So, yun.
Okay, so the next topic is the Title 7 of the Corporation Code, which focuses on stocks and stockholders. So, what do we mean by stockholders? So, stockholders are individuals who owns a share of stock in a corporation. They are generally the owners of the corporation and are considered as risk takers who invest capital in a corporation. Risk takers because there is only 50-50 chances that the corporation might gain profits or loss after the debts and liabilities. So we have two types of corporation, which are the stock corporation and the non-stock corporation. So in stock corporation, shareholders may generally transfer their shares, but when the shareholders passes away, the shares doesn't automatically transfer to their heirs or beneficiaries, but rather to the executor or administrator appointed by the court to manage or handle the shares until it is transferred to the heirs and beneficiaries of the shareholders. On the other hand, in non-stock corporation, the shares and rights of the shareholders are personal to him, so therefore it is non-transferable, but unless otherwise provided by the buyer court. So in conclusion, the transfer may be executed through the article of the incorporation. Okay, so how do shareholders protect the corporation from the wrongdoings of the insiders, such as the directors or the officers? Okay, so if the insiders of the corporation committed an unlawful act, then the shareholders may file a derivative suit. So this suit is an effective remedy for the minority against the abuse of management, and it will help the corporation by holding those individuals accountable. Okay, so what are the requisites of the derivative suit? So first, the party bringing the suit must be a shareholder of the corporation. So the derivative suit was specifically made for the shareholders to protect the corporation. So you must be a shareholder to file a derivative suit. Second, he has tried to exhaust intra-corporate remedies. Okay, so before filing the derivative suit, the shareholder must try to exhaust intra-corporate remedies, and if that fails, he can then file a derivative suit. Lastly, the cause of action actually devolves on the corporation itself and not to the particular shareholders bringing the suit. Okay, so as I said before, the derivative suit is specifically made for the shareholders to protect the corporation and not to protect themselves. Okay, so aside from the derivative suit, we also have individual and class suit. So individual suit is a suit filed by a shareholder who is denied the right of inspection. So this suit is called individual because the wrong is done directly to him and not to others or to the corporation. Next is the class suit or representative suit. So this suit is filed by a group of shareholders of a corporation who had their preferred stock rights violated. Okay, so next is subscription contract. So subscription contract is a consensual contract and an indivisible contract. According to section 59, any contract for the acquisition of an issued stock in an existing corporation or a corporation still to be formed shall be deemed a subscription within the meaning of this title, notwithstanding the fact that the party referred to it as a purchase or some other contract. Okay, so for example, I acquired an issued stock from ABC Company, which is an existing corporation. So the contract between me and ABC Company shall be considered as subscription contract, even though ABC Company referred to it as a purchase or any other contract. Okay, so next is section 60. So section 60 talks about the pre-incorporation subscription, which refers to a subscription for shares of stock for a corporation still to be formed. So we have two rules governing this section. First, upon the subscription, it is irrevocable for at least a period of 6 months unless other subscribers consent to the revocation. Okay, so it says here that from the day of subscription, if you're thinking you want to revoke your subscription, you have to wait for at least 6 months to be able to do it, unless other subscribers consent for your revocation. Other than that, you may also revoke your subscription if the corporation fails to incorporate within the same period or within a longer period stipulated in the contract of subscription. Okay, so that's the rule number 1. Next is rule number 2. So, rule number 2, after the submission of the article of the incorporation to the SEC, no pre-incorporation may be revoked. Okay, so it says here that when the corporation submits the bylaws to the SEC or the Securities and Exchange Commission, revocation may not be allowed. Okay, so aside from pre-incorporation subscription, we also have post-incorporation subscription, which refers to an acquisition of an issued stock for an existing corporation. Okay, so this is the section 61. I'm going to sum it up for you to understand clearly. Okay, so according to this section, stocks shall not be issued for a consideration less than the par or issued price thereof, because if so, the finances of the corporation will get hurt, and the creditors and shareholders of that corporation will be affected unfairly. Okay, so above are the considerations of the issuance of stocks. You can zoom in so that you can read it clearly. Okay, so let's continue. If the consideration is other than actual cash or consists of intangible property, then the valuation shall be initially determined by the stockholders or the board of directors, which is subject to approval of the SEC or the commission. In addition, stocks shall not also be issued in exchange of promissory note or a future service. Okay, next is section 62. According to the section 62 of Revised Corporation Code, no transfer, however, shall be valid except between the parties until the transfer is recorded in the books of corporation, showing the names of the parties to the transaction, the date of the transfer, the number of the certificate or certificates, and the number of shares transferred. Okay, so to sum it up, it says here that the shares of stock is a personal property of a shareholder, therefore can only be transferred by a person who is legally authorized to make the transfer. But if the transfer is not recorded in the stock and transfer book, which is the only basis of the corporation to determine who are its shareholders, then the corporation may not regard or may not consider the transferee as a shareholder. Okay, next is section 63, which is about the issuance of stock certificate. So what is a stock certificate? So this is an evidence of the holder's ownership of the stock and his right as a shareholder. So according to this section, if the full amount of the subscription along with the interest and expenses in case of delinquent shares are not fully paid, then no certificate of stock shall be issued. So in simple terms, the shareholders must pay the full amount of the subscription along with the interest and expenses in case of delinquent shares for a certificate of stock to be issued. Okay, next is section 64, which is about liability of directors for watered stocks. Okay, so what is a watered stocks? So watered stocks refers to a share issued by a corporation in exchange for assets that are worth less than the stock's par value. Okay, so if the directors issued a watered stocks, then they are liable for the corporation or for its creditors and its shareholders. Okay, next is section 65, which is about interest on unpaid subscription. Okay, so according to this section, if a subscriber has not paid for their subscribed shares, then interest will accumulate on the amount unpaid for the date of subscription, and they are liable for this. The rate for this interest is usually fixed in the subscription contract, but if not, then the prevailing legal rate shall apply. Also note that the interest on unpaid subscription will only accumulate or arise if the subscription contract requires it.
Title 7 Stocks and Stockholders. Section 66 Payment of Balance of Subscription. It is stated here that subject to the provisions of the subscription contract, the Board of Directors may at any time declare due and payable to the corporation unpaid subscriptions and may collect the same or such percentage thereof, in either case with accrued interest, if any, as it may deem necessary. Payment of unpaid subscription or any percentage thereof, together with any interest accrued, shall be made on the date specified in the subscription contract or on the date stated in the call made by the board. Failure to pay on such date shall render the entire balance due and payable, and shall make the stockholder liable for interest at the legal rate on such balance, unless a different interest rate is provided to the subscription contract. The interest shall be computed from the date within 30 days from the said date. All stocks covered by the subscription shall thereupon become delinquent and shall be subject to sale as hereinafter provided, unless the board of directors orders otherwise. So under this section, the board of directors can declare unpaid subscriptions due and payable at any time. Payment should be made by the date specified in the subscription contract, or if wala, on the date set by the board. If not paid on time, the total amount becomes due and interest begins to accumulate. If there's no payment within 30 days of the due date, the subscribed stocks become delinquent and may be sold unless directed otherwise by the board. Note: these sections procedures for stock corporations do not apply to non-stock corporations concerning member dues. Section 67 Delinquency Sale. It is stated here that the Board of Directors may, by resolution, order the sale of delinquent stock and shall specifically state the amount due on each subscription plus all accrued interest, and the date, time, and place of the sale, which shall not be less than 30 days nor more than 60 days from the date the stock become delinquent. Notice of the sale with a copy of the resolution shall be sent to every delinquent stockholder, either personally, by registered mail, or through other means provided in the bylaws, and the same shall be published once a week for 2 consecutive weeks in a newspaper of general circulation in the province or city where the principal office of the corporation is located, unless the delinquent stockholder pays to the corporation on or before the date specified for the sale of the delinquent stock the balance due on the former subscription plus accrued interest, cost of advertisement, and expenses of sale, or unless the board of directors of otherwise orders. Say delinquent stock shall be sold at the public auction to such bidder who shall offer to pay the full amount of the balance on the subscription together with the accrued interest, cost of advertisement, and expenses of sale for the smallest number of shares or fraction of a share. The stock so purchased shall be transferred to such purchaser in the books of the corporation, and a certificate for such stock shall be issued in the purchaser's favor. The remaining shares, if any, shall be credited in favor of the delinquent stockholder, who shall likewise be entitled to the issuance of a certificate of stock covering such shares. Should there be no bidder at the public auction, who offers to pay the full amount of the balance on the subscription together with accrued interest, cost of advertisement, and expenses of sale for the smallest number of shares or fraction of a share. The corporation may, subject to the provision of this code, bid for the same, and the total amount due shall be credited as fully paid in the books of the corporation. Title to all the shares of stock covered by the subscription shall be vested in the corporation as a treasury shares and may be disposed of by said corporation in accordance with the provisions of the code. Under Section 67, Delinquency Sale, sabi rito na ang board can order the sale of the delinquent stock and that stating the amount due and details of the sale, including the date, time, and location. So notice is important. Notice of the sale must be sent to the delinquent stockholders and published in a local newspaper weekly for 2 weeks. And if the delinquent stockholder naman doesn't pay by the sale date, the stock is sold at a public auction. And if no bidders appear, the corporation itself may bid, and that the stock will be considered fully paid. By this, the corporation can hold the shares as a treasury shares and may dispose of them later. But who is a highest bidder ba? Is the bidder who shall offers to pay the full amount of the balance on the subscription together with accrued interest, costs of advertisement, and expenses of sale, the smallest number of shares or fraction of a share. Let's get to know the two way of payment of unpaid subscription. Two, the voluntary payment and involuntary payment. When we say voluntary payment, this payment shall be made on the date specified in the contract of subscription or on the date stated in the call made by the board. And the involuntary payment, we have the extrajudicial and judicial action. Under extrajudicial, we have the delinquency sale, wherein the board of directors may, by resolution, order the sale of delinquent stock. And the second one is the application of dividends, wherein the cash dividends due on the delinquent stock shall first be applied to the unpaid balance on the subscription plus cost and expenses, while stock dividends shall be withheld from the delinquent stockholder until his unpaid subscription is fully paid. Then the second one, in involuntary payment, we have the judicial action, wherein the corporation can collect by action in a court of proper jurisdiction the amount due on any unpaid subscription with accrued interest, costs, and expenses. Then let's continue with the section 68. When sale may be questioned, it is stated here that no action to recover delinquent stock sold can be sustained upon the ground of irregularity or defect in the notice of sale, or in the sale itself of the delinquent stock, unless the party seeking to maintain such action first pays or tenders to the party holding the stock the sum from for which the same was sold, with interest from the date of sale at the legal rate, and no such action shall be maintained unless a complaint is filed within 6 months from the date of sale. So sabi sa section 68, when sale may be questioned. First, legal actions to recover sold delinquent stock cannot proceed due to irregularities unless nga ang complainant is magbayad doon sa sale amount plus interest. At ang complaints must be filed within 6 months of the sale date. So let's go to section 69, court action to recover unpaid subscription. It is stated here that nothing in this code shall prevent the corporation from collecting through the court action the amount due on any unpaid subscription with accrued interest, costs, and expenses. So, we're talking about the corporation that it retains the right to collect the unpaid subscriptions through legal action, including the interest and cost. Let's continue with the section 70, effect of delinquency. It is stated here that no delinquent stock shall be voted for, be entitled to vote, or be presented at any stockholders' meeting, nor shall the holder thereof be entitled to any of the rights of a stockholder except the right to dividends in accordance with the provision of this code until and unless payment is made by the holder of such delinquent stock for the amount due on the subscription with accrued interest and the cost of expenses of advertisement if any. Sabi dito na ang delinquent stock cannot be voted on or represented at meetings at the holders lose stockholder rights except for dividends until dues are paid. And note that delinquent stockholders are not counted for quorum purposes but can still receive dividends. Then we have the section 71, the rights of unpaid shares, non-delinquent. It is stated here that holders of subscribed shares not fully paid, which are not delinquent, shall have all the rights of a stockholder. It simply means that holders of unpaid but not non-delinquent shares maintain all stockholder rights. Then we have the section 72, lost or destroyed certificates. Following procedure shall be followed by a corporation in issuing new certificates of stock in lieu of those which have been lost, stolen, or destroyed. First, the registered owner of a certificate of stock in a corporation or such person's legal representative shall file with the corporation an affidavit in triplicate setting forth, if possible, the circumstances as to how the certificate was lost, stolen, or destroyed, the number of shares represented by such certificate, the serial number of the certificate, and the name of the corporation which issued the same. The owner of such certificate of stock shall also submit such other information in evidence as may be deemed necessary. Then we have this B. After verifying the affidavit and other information and evidence with the books of the corporation, the corporation shall publish a notice in a newspaper of general circulation in the place where the corporation has its principal office once a week for 3 consecutive weeks at the expense of the registered owner of the certificate of stock which has been lost, stolen, or destroyed. And so on, kung babasahin mo ito lahat, under Section 72, it talks about the lost or destroyed certificate, na kung saan ang owners of lost, stolen, or destroyed stock certificates must submit an affidavit detailing the circumstances or pangyari and other relevant info into the corporation. Then the corporation verifies the information and publishes a notice in the local newspaper for 3 weeks at the owner's expense. If no contest arises within a year, certificate is cancelled and the new one is issued unless nga lang a bond is filed. If a contest or legal action regarding dun sa certificate is pending, ang issuance ng new certificate is paused until it is resolved. Corporation is protected from actions that concerning the new certificates unless there was fraud, bad faith, or negligence. Then we have here the rights of the stockholders. Rights of the stockholders and management rights, proprietary rights. and the remedial rights. Of course, it is stated also here the liabilities of a stockholders. It's liability for the unpaid subscription, liability for interest on unpaid subscription, liability to creditors of the corporation on the unpaid subscription, liability for watered stock, and the liability for dividends of unlawfully paid.
Hi everyone, I am Raja Sofia Datukan and now let's talk about the corporate books and records. So today I'll be sharing important information about the section 73 of the Corporation Code, which outlines the essential records that corporations must maintain. So these records are crucial for ensuring transparency, accountability, and smooth business operation. So under Section 73, corporations are required to keep the following records at their principal office. First is the Articles of Incorporation and Bylaws. These are the foundation of the corporation, defining its structure, purpose, and internal rules. They guide how the company operates and ensure all actions align with legal standards. Second is the ownership structure and voting rights. So this record contains details about stockholders or members, their ownership shares, and voting powers. So this ensures fair participation in corporate decisions. Third is the names and addresses of directors and officers. Keeping this updated is important for easy identification and communication with key decision makers. Fourth is the record of business transactions. This serves as a financial log documenting the corporation's economic activities for tracking and auditing purposes. Fifth is the resolutions from the board and stockholders. These are records of key decisions made during meetings, ensuring clarity on corporate actions. Sixth is the latest reportorial requirements. These are documents that corporations submit to regulatory bodies such as SEC to comply with legal obligations. Lastly is the minutes of meetings. So these detailed records summarize discussions, decisions, and agreements made during official meetings. All these records must be carefully preserved at the corporation's principal office to ensure easy access for inspection when necessary. Maintaining these records properly is essential for corporate governance, legal compliance, and building trust with stakeholders. Next is the inspection right and penalties. So I'll be explaining the important aspects of corporate governance, the right to inspect corporate records, and the corresponding restrictions and penalties under the law. First is the right to inspect records. Directors, trustees, stockholders, or members have the legal right to inspect corporate records. However, this must be done under reasonable conditions, meaning the request should be made in good faith and for a valid purpose, like ensuring the corporation's proper management. Next is the restrictions on inspection. Not everyone can access these records. For example, is the competitors or individuals acting with malicious intent are not allowed to inspect corporate records. This rule protects the company from potential harm or data misuse. Next is the penalties for abuse. If someone abuses their inspection rights or improperly uses corporate information, they can face serious penalties. This includes violations under the Intellectual Property Code, the Data Privacy Act, and other related laws. In short, while inspection rights are granted to protect stakeholders, safeguards are also in place to prevent abuse and protect the corporation's sensitive information. Proper use of this right ensures fairness and accountability in corporate practices. Next is I'll be discussing two important rights that stockholders should know: the right to financial statements and the right of inspection under the Corporation Code. Corporations are required to provide their financial statements within 10 days after receiving a written request from a stockholder. This ensures transparency and allows stockholders to stay informed about the company's financial health. For small corporations, those with total assets or liabilities below 600,000, a simplified financial statement may be submitted. This statement must be certified by both the President and Treasurer to ensure its accuracy. Next is the stockholders' right of inspection. Stockholders have the right to inspect corporate records because they are part owners of the company. This right helps protect their interests and ensures that the corporation is being managed properly. However, This right is not absolute. Inspections may be denied if the person is acting out of malice, curiosity, or for harmful intentions. So this restriction prevents misuse of confidential information. Both rights are designed to promote transparency, accountability, and protection for stockholders while ensuring the corporation's information is handled responsibly. So next is the two important elements in corporate record keeping, the stock and transfer book and the stock transfer agent. Both are essential for tracking stock ownership and ensuring smooth transactions. So in stock and transfer book, this book is a crucial corporate record that must include the following details: the list of stockholders, which organized alphabetically for easy reference, paid and unpaid subscriptions. So these tracks which stockholders have fully paid for their shares and those who still have pending payments. Next is the records of sales, donations, and transfers. So any movement of shares, whether through sale, gift, or transfer, must be documented to maintain accurate ownership records. So next is the stock transfer agent. So for corporations that trade stocks in secondary markets, appointing a stock transfer agent is required. This agent handles the registrations of stock transfers, ensuring all transactions are properly recorded and legally compliant. So by maintaining an updated stock and transfer book and working with a licensed stock transfer agent, corporations can ensure accurate records, protect stockholder interests, and comply with regulatory standards. That would be all. Thank you.
Good day everyone, I am Quincy Bestorninos and I will be reporting the merger and consolidation. So as a rule, a corporation that purchases the assets of another will not be liable for the debts of the selling corporation, provided na yung former corporation acted in good faith and paid adequate consideration for such assets, except kapag yung following circumstances is present. First, if the buyer agrees to take on a debt. Second, if the purchase is essentially a merger or consolidation. Number 3, if the buyer is just continuation of the seller. And number 4, if the deal was made to avoid paying debts. Next, on Section 75, Plan of Merger or Consolidation. So dito, gina-permit lang yung merger or consideration kapag na-state ng 2 or more corporations can either merge into an existing corporation kung saan yung isa ay mas makasurvive or mag-consolidate sila into a completely new corporation. Tapos, dapat merong board approval. The core requirement nito is that the board of directors or trustees of each participating corporation must approve a plan of merger or consolidation. Ang content dapat ng plan nila kaya dapat i-include nila yung specific information, which are the names of the corporations. It must be clearly identified. It must clearly identify the corporations involved in the merger or consolidation. Letter B, terms and mode of implementation. It must be detailed in terms of the merger or consolidation and kung paano siya ma-carried out. Letter C, changes to articles of incorporation. Ito yung kapag yung merger, kaya dapat ma-state dito na yung any changes sa article of incorporation of the surviving corporation. And if consolidation naman, kaya dapat i-include lahat ng necessary statements na required for the articles of incorporation of the new corporation being formed. And letter D, other necessary provisions. It allows for the inclusion of any other provisions deemed necessary for the proposed merge or consolidation. So, in simple terms, kay ang Section 75 is like ito yung starting point ng company. Ito yung starting point ng company for combination. Gina-combine, sinasabi dito kay companies can combine. Tapos dapat makaplan sila. Tapos dapat meron yung mga key informations niya. Like sino ang mag-combine, paano sila i-combine, ano yung changes na mangyayari, and anything else na important pa. So essentially, this section sets the stage for the formal process of merging or consolidating corporations, emphasizing the need for what a well-defined or board-approved plan. Next, what is merger? A merger is a union whereby one or more existing corporations are absorbed by another corporations that survives and continues the combined business. So dito siya kay parang yung one company is absorbed by another existing company. Tapos yung absorbing company kay mag-survive. Ginatake nito lahat ng assets and liabilities ng gi-absorb na company. So, ito siya parang swallow ng isang company ang another company. As of consolidation naman, a consolidation is the union of two or more existing entities from a new entity called the consolidated corporation. So, two or more companies combine to create a completely new company. The original company ceased to exist. Imagine building a brand new company from the parts of two older ones. Ganon ang atake niya. Law authorizing merger or consolidation. Mergers and consolidations require express legal authorization. They involve fundamental changes to a corporations. They impact the rights of stockholders and creditors. Corporate mergers and consolidations require explicit legal authorization because they significantly alter company structures and stakeholders' rights. One company survives absorbing others' assets and liabilities without liquidation. This isn't a simple agreement pero ito ay complex legal process na nag-ensure ng fairness and protecting the stockholders and creditors. Next is Section 76. Dito naman is gina-outline nito yung process ng pag-obtain ng approval galing sa mga stockholders or members ng corporations na involved sa merging and consolidating. So dito, yung board approval prerequisites, it reiterates that the plan of merger or consolidation must first be approved by a majority vote of each corporation's board of directors or trustees. For the stockholders or member approval naman, once na mag-approve yung board, the plan is submitted to the stockholders for stock corporations or members members naman for non-stock corporations para sa kanilang approval. Tapos mayroong separate meetings na nangyayari. Yung each corporation must hold separate meetings for its stockholders or members para mag-vote para sa plan. Meron namang notice requirements na binibigay. Proper notice of these meetings must be given to all stockholders or members. The notice must state the purpose of the meeting, include a copy of summary of the merger or consolidation plan. The notice must be given in the same manner as notice for regular or special meetings, referencing Section 49 of this code. Ang required vote naman is a supermajority vote is required for approval. For stock corporations, at least 2/3 ng outstanding capital stock. For non-stock corporations naman, at least 2/3 ng members. Dissenting stockholders' right. So, dissenting stockholders have the right of appraisal, meaning they can demand that the corporation buy back their shares at a fair value. However, if the board decides to abandon the plan after stockholder approval, the right of appraisal extinguished. Amendments. Ang amendments naman ng merger to the merger or consolidation plan are allowed. Yung amendments must be approved by a majority vote of a respective boards of directors or trustees, ratified by two-thirds votes of stockholders or members of each corporation. As of the agreement naman, the approved plan, along with any amendments, constitutes the final agreement of merger or consolidation. In simple terms naman, the Section 76 is about getting the owners of the companies na mag-agree na mag-merge or mag-consolidate. Dito kay dapat yung mga boss kay magsabi ng yes muna, tapos yung mga owners kay pwede sila after that yung mga owners is mag-vote na, and then everyone gets a notice about the vote and what they are voting on. It takes a big majority, 2/3, to say yes. If you don't like it, you might be able to get your shares bought back. If they change the plan naman, everyone votes again. Once everyone agrees, that's the final deal. So essentially, this section ensures na yung owners ng corporation kay merong significant say in whether or not the merger or consolidation takes place, and that their rights are protected. Section 77, Articles of Merger or Consolidation. This section outlines the requirements for formalizing a merger or consolidation after stockholder or member approval, as per Section 76 discussed in the previous response. So, formal agreement, meron silang formal agreement. Ito siya kung paano siya ginawa. Each constituent corporation must execute articles of merger or consolidation signed by their president or vice president, and dapat i-certify ito by their secretary or assistant secretary. Content of the articles, kaya dapat ang laman niya nito is letter A, the plan of merger or consolidation. Letter B, number of outstanding shares or members for stock and non-stock corporations, and votes for or against the plan. Letter C, carrying amounts and fair values of assets and liabilities. Letter D, method of merging or consolidating accounts. Letter E, provisional or pro forma values using the accounting method. Letter F, other information as required by the SEC. Section 78. These documents outline the effectiveness of a merger or consolidation, focusing heavily on the role of the Securities and Exchange Commission or the SEC in the Philippines. So dito, the section emphasizes that a merger or consolidation is not valid until the SEC approves it. This approval is formalized by the SEC issuing a certificate approving the articles and plan of merger or consolidation. Special corporations and government agency approval. If the merging or consolidating corporations are special corporations like banks, insurance companies, public utilities, and etc., that are regulated by specific laws, they must first obtain a favorable commendation from the relevant government agency before submitting their documents to the SEC. So, for the SEC's review and approval process, the articles of merger or consolidation which have been signed and certified by the corporations must be submitted to the SEC for approval. The SEC will examine these articles para i-ensure na consistent with the provisions of this code and existing laws. If the SEC is satisfied that everything is in order, it will issue the certificate of approval. As of the SEC hearing naman, if necessary, if during its investigation, the SEC finds that the proposed merger or consolidation is contrary to or inconsistent with the law, it will schedule a hearing. This hearing gives the corporations involved an opportunity to present their case. The corporations must be given written notice for the hearing at least 2 weeks in advance. After the hearing, the SEC will proceed according to the law. Effectivity of merger or consolidations. The merger or consolidations becomes effective only kapag yung SEC is nag-issue na siya ng Certificate of Approval. Specifically, for consolidations, the issuance of this certificate marks the official beginning of the new consolidated corporation and the end of the original corporations. So, in Section 78, essentially establishes that you can just decide to merge or consolidate and have it to be legal. You need the government's or the SEC's official permission. Certain types of company need extra permission from other government offices first. The SEC checks everything to make sure it follows the rules. If there are problems, the SEC holds a meeting to hear from the companies. The merger or consolidations is only official kapag nag-give na yung SEC ng okay in writing. This section highlights the importance of government oversight in corporate restructuring or to ensure compliance with the law and protect the interest of stakeholders. Section 79, Effects of Merger or Consolidation. So this explains the legal process and effects of mergers and consolidations. So we know that merger versus consolidation, the merger is one company survives absorbing the others, while the consolidations is a new company formed from emerging entities. So, pag yung SEC approval is essential. Mergers and consolidations are not effective until the Securities and Exchange Commission issues a certificate of merger or consolidations. This approval follows the approval of the articles of merger or consolidations by the stockholders of the involved corporations. So, ang effects of merger and consolidations is the letter A is the constituent corporations become a single entity, surviving or consolidated corporations. Number 2, the absorbed corporations cease to exist. Then the surviving or consolidated corporations inherits all rights, privileges, immunities, powers, assets, and liabilities of the constituent corporations. And the letter E, pending legal actions involving the absorbed corporations are continued by or against the surviving or consolidated corporations. Creditors' rights are not impaired. Importance of the certificate issuance. The date of the SEC certificate is the official moment the merger or consolidation takes effect, marking the transfer of assets and liabilities and the dissolutions of the absorbed companies. In short, Philippine law mandates Securities and Exchange Commission oversight and a formal certification process to ensure that mergers and consolidations are legally sound, transparent, and protect the interest of all stakeholders. And that concludes our report. Thank you for listening.